Item number 1 and 2.
Before my learned friend begins, this is that matter, regarding that MRI machine to be installed in Tura. What I am instructed is there is some development insofar as the respondent is concerned. They are in the process of writing to the government with something which would have a bearing insofar as these appeals are concerned. May I pray your lordships kindly have this matter tomorrow. We'll try and have the matter sorted out today. So your lordships may not then be required to go into the appeal in the first place. I'm not in a position to make a statement at this moment, but hopefully, we'll be in a position to close this matter tomorrow.
We will keep it on the 6th of February.
As your lordships may please.
By consent of learned counsel for the parties, this appeal is adjourned till 6th February. One and two.
Yes, my lord.
These appeals.
Yes, my lord.
1 and 2, one order.
Lord, may I make only one request, my lord? Could it be on the 7th, my lord, if at all possible? I'll need to travel from Delhi, my lords, if at all possible.
No, it's very much possible. 7th is
7th. Obliged.
Item number 3.
We've taken steps for service of notice upon the private respondent. It's been served. Served. Services, my lords, I'm instructed it is complete, my lords, and an affidavit has been filed. We filed an affidavit on 27th of January 2025. My lords, there's a very limited issue in this appeal. If I'm just permitted to take your lordships to the impugned order, my lords.
The respondent is not appearing. They've been served.
They've been served, my lords. We filed an affidavit of service as well.
The respondent is Union of India.
My lords, the writ petitioner is the main respondent who was not served. Union of India we've already served earlier.
The writ petitioner has been served.
Served, my lords. We filed an affidavit. Otherwise, also, my lords, the portion of the order that, my lords, is assailed with your lordships does not really affect the writ petitioner.
There is an interim order in their favor.
No, my lords, there is an interim order in our favor passed by this honorable court, my lords. There was some direction by the learned single judge for payment of costs and some disciplinary proceedings that has been stayed, my lords.
You have Bharat Petroleum.
My lords. This entire appeal emanates out of some confusion that happened before the learned single judge. I'll just place it, my lords.
No, the direction contained in the impugned order to initiate disciplinary proceedings,
My lords.
that is against the writ petitioner.
No, that is against us, my lords.
Against Bharat Petroleum.
What had happened, my lords, is the learned single judge, my lords, was under a misconception that there has been a settlement of the RO dealership with the, my lords, some third party. The case of the petitioner, writ petitioner itself is that it has not been settled. We, my lords, had informed that only the drawing of lots was complete and the process of verification is going on. Now, the learned single judge, my lords, takes exception and says that no, you have settled it with somebody and therefore, my lords, cost imposed and disciplinary proceedings initiated. That is the limited case before your lordships.
Against whom in Bharat Petroleum?
It is unnamed, my lords. It simply says, my lords, concerned officials, my lords. Well, it's paragraph 15. The same is deprecated, and it is expected that necessary appropriate disciplinary action be instituted against the officers concerned who are responsible for misleading the court.
Let us give them another chance to appear. The interim order should continue.
As my lords feel appropriate. Well, it's, what I should bring to your lordship's notice is that the writ petitioner himself submits before the learned single judge, my lords, that there has been no settlement of the RO dealership with anybody. So it was nobody's case, my lords, that it has been settled. The learned single judge, my lords, on the basis of some affidavit, which again does not say that there has been any settlement, makes this observation in paragraph 15.
All right. Mr. Paul, learned senior advocate, appearing for the appellant, that the respondents have been duly served and that an affidavit of service to that effect has been filed in court. We accept the submission with regard to due service. Paragraph. None appears for the respondents. We are minded to give them another chance to appear. List this appeal and application once again on 31st. Let it appear on 31st.
31st. Right.
On 31st, full stop, we will make it clear that if on that day none appears for the respondents, this appeal will be dealt with ex parte.
Well, it's the interim order may kindly be continued.
Yes. The interim order made on 17 December 2024 shall continue until further orders. Advocate on record for the appellant shall notify the respondents of this order in course of today.
Well, it's highly benched.
Item number 49.
Yes. Yes.
May please, your lordships. Also, these are bunch of writ appeals, my lord. We're challenging the, my lord, the impugned judgment of the learned single judge, my lord, which is page 69, my lord. My lord, the brief facts of the case, my lord, here. The writ, my lord, the appellants herein, my lord, they were temporarily, my lord, appointed way back in the year 2013, 2012. And my lord, surprisingly, my lord, in the year 2015, my lord, the salary of the writ appellants, my lord, were stopped without any reason, my lord.
Where is the impugned order?
My lord, it is at page 69, my lord.
69.
69 of the writ appeal, my lord.
In my copy, it is at page 74, Your Lordship.
Which
Yes, that is right.
first is? No, no, no. In first is? No. It's appealing. What's item?
What's item?
Yes. Take out. Take out. Is the first item? No, yeah, this is affidavit. In front of this. On top. Can you hold up?
These are not here.
Top.
Yes, a second.
Who is that? It is surprising. I keep the sequence. Is this?
When you prefer these writ applications for payment of your arrears, salary, etc., you did not ask for any renewal?
My lord, there was no apprehension as such, my lord, that I'll be discontinued. So, my lord,
At that time, you were in service.
my lord, yes. Now, surprisingly, my lord, there are other similarly situated, my lord, candidates. Total number of 30, my lord. 9 had approached the Honorable Court for releasing of their salaries, my lord. Now, as a backlash, my lord, the petitioners who had approached the Honorable Court,
Yes.
their services were not renewed, whereas the rest 21, they are still in service, my lord. So, my lord, this is a backlash, my lord, for dragging the mighty authorities in the court, my lord. That is my case, my lord.
But they could only renew it for 3 months. 3 months only.
My lord, because that was the, my lord, practice at that point of time, my lord. After.
How old are you now?
My lord, I'm 42, my lord. My lord, my case is squarely covered by, my lord. There is a Supreme Court judgment, my lord, of 1991, my lord. Similar case, my lord, where the juniors were retained, my lord, and the petitioner who had approached the court, my lord, they were left out, my lord. Their service were not renewed, my lord.
But other persons have already been appointed
My lord.
in 2018 or 19.
No, my lord, some their service has been regularized, my lord. Some are still, their, my lord, service has been renewed, my lord. Some have been renewed, my lord. It is in their additional affidavit, my lord.
Madam, is there any vacancy now?
No, Your Lordships.
Huh?
Your Lordships, there are no vacancies, Your Lordships. All these positions which have been filled out by regular employees who have come to the selection board, Your Lordship.
All filled up.
DSC by the District Selection Committee and as well as those landowners, Your Lordship. So there is no vacancy as of now, Your Lordship, in these posts.
6.
In addition,
They were temporary employees of the government or any local body?
no, they were of the government, but they were appointed by at the district level without going through the regular selection procedure and without seeking the approval of the competent authority, Your Lordship. So for time and again, their services were being renewed after every 3 months with a break. And then finally, it was because the government had took up the position stand that they would not allow any temporary appointments to be made. And so that, which is why, Your Lordship, that was stopped.
Filled up in 2019.
2000. Some of them were in 2019, Your Lordship. Some in 2020, some in 2019, Your Lordship. After they were recommended by the District Selection Committee, as well as they were a relative of the landowners. Your Lordship, my additional affidavits, of course. Lordship, but this issue, Your Lordship, that 31 employees were, out of 31, only 9 were picked up and their services not renewed, were never raised before the single bench, Your Lordship. This is a new pleading before the appellate court, Your Lordship. Now, Your Lordship, those 31 employees also, and none of them are parties before this court, Your Lordship.
But their services were renewed.
They were renewed up to 2017, Your Lordship.
So thereafter, except 9, others were
No,
renewed.
they were also not renewed, Your Lordship. Their positions were also filled up. We've given an additional affidavit, Your Lordship.
Later. But from 2017 to 19, they were renewed on ad hoc basis.
My lord, yes.
No, they all got regular appointments, Your Lordship, but the actual date of their services being regularized has not been, because they were also, after they appeared.
Till they were regularized, the ad hoc appointments were renewed.
No, Your Lordship.
My lord, kindly come to page 3 of the additional affidavit. Bring on record the status of. My lord will come to page 3, my lord.
3, Your Lordship.
Column 5, officiating is renewed. Then column 18, officiating is renewed. Column 14, officiating is renewed. All are renewed, my lord.
No, they have all been renewed by the competent authority, by the Director of Health Services. Your Lordship, I may kindly bring to your notice that.
Except 9 who came to court.
No, the others all, Your Lordship may kindly see at page 3 of my additional affidavit.
Page
3 of my additional affidavit, Your Lordship, to bring on record the status of the 31 officiating employees, which was filed in 21/6/24, Your Lordship. The first one, Your Lordship, Yutinder Dora Marbanyang, Peon DFP, her date of joining was on 2014. The post has now been filled up by Shri. She was an officiating employee, and her post has been filled up by one regular casual worker, Your Lordship. So she is not continuing. Then again, Ermelinda Marvin, she was working as a cook in an officiating basis, and she was granted a temporary by the Director of Medical and Health Services, West Khasi Hills, Nongstoin, by the competent authority, Your Lordship. Then this Bunsito Linkroy was, as in 2014, vacant, Your Lordship. Then this one, Fromlin Rani Ward, also has been given the appointment, being a landowner, a relative of the landowner. Then Ridalin Maukhan her officiating is renewed by the Director of Health Services, not at the district level, but at the state level. Then Paul Lingdor Longlight at number 6, Your Lordship. The post has now been filled up by Shri Walter Kharmaulang, regular casual worker, as per office memorandum dated 16th September 1996. Then Ribhaling, she has been regularized. Then, Your Lordship, these 9, then at number 8 also granted regular appointment, being landowner. So, and Listino Basayomet is the writ appellant before this court. Her post has been filled up by by a candidate recommended by the District Selection Committee. Again, number 10 is also a writ appellant, Your Lordship. His post has been filled up by a regular casual worker. Yamunwang Marbanyang, which is the first item number 4, which is now before Your Lordships. This has also been filled up by a DSC recommended candidate, District Selection Committee.
No, when it was filled up and till it was filled up, was the temporary appointment renewed?
The temporary appointment, it was not renewed, Your Lordship. It was left vacant. As far as these writ appellants were concerned, once that appointment was not renewed, Your Lordship, it was left vacant because their services were no longer required. So it was not filled up by any other officiating employees. It was only after a couple of years before the District Selection Committee had recommended any candidates, Your Lordship, due to meet some exigencies, a temporary appointment was made just for 49 days, Your Lordship. but by some other candidate. Then when the district selection committee appointed a regular candidate, that candidate's term was also over, Your Lordship. I can take Your Lordship to
No, if you come to the judgment,
Yes, Your Lordship.
page 1 of the judgment, there appears to be 9 writ petitioners.
Yes, Your Lordship. And their last date of renewal is as on 17, 18. At serial number 4 and 5, they are not the appellants here before Your Lordships. 1, 4, and 5.
3 appellants.
My lord,
We have
there are-
6 appellants before Your Lordships, because here there are 9 names, out of which 3 have not filed any appeal, Your Lordship.
If I may, my lord.
Yes.
My lord, we'll come to page 57, my lord. That is the impugned order, my lord, under challenge, my lord. Page 57. That is the letter dated 19 February 2019. Letter dated 19/2/2019. If I may read, madam.
Yes.
In continuation of this director's letter number so and so, dated 19/2/2019, I request you to comply to the court's order dated 15/11/2018, thereby releasing their pay and allowances only for the period as per the appointment order issued. Further, you are hereby instructed not to renew the appointments. Renewal of service will be made without prior approval from the competent authority. This is for your information. Now, my lord, write this letter, my lord.
Yours is which page? 57 is not that letter. What is the date of the letter?
It's 19th February 2019.
Correct.
Page 61, Your Lordships.
Page?
61.
My lord, if there is pagination mistake, my lord, I pray this matter may be postponed for a week, my lord. I'll correct it.
The total is, madam, page 3 of your affidavit. Total number of employees, ad hoc employees.
31, Your Lordship. But I beg to submit, Your Lordship, that this issue was never raised, that 31 employees were there and then all of them were renewed and all that, which was never raised before the single bench, Your Lordship. Now there's a new issue, pleading, which has come up before the division bench. And so what was not raised before the single bench, whether it can be pleaded before the appellate court, Your Lordship.
That these 9 were left out because they had filed with petitions.
No, that the 31 of them were there, out of which all of them were renewed and only they were not renewed.
My lord, I raised that plea, my lord. It is very much there, my lord.
Not in
there are 9, my
specific
lord.
terms, Your Lordship.
There are 9 of, my lord, my writ appeal, my lord, page 44. I have specifically...
No, I'm talking about being raised before the single bench, Your Lordship, in the writ petition. And again, Your Lordship, some attachments have been, annexures have been attached here before in the memo, which were not part of the document before the single bench, Your Lordship.
Please, who is this?
So where have you pleaded that in the writ petition that 9 were excluded
My
because
lord,
they went to court?
my lord, at page 44, my lord. Page para 9, my lord.
Paragraph?
9, my lord. If I may read, my lord. That it is pertinent to mention here that the respondent number 4 had made 31 appointments similar to that of your humble petitioner, and 9 individuals, including the petitioner, had approached this honorable court for a direction for disbursement of the salaries, whereby the individuals have brought upon them the wrath of the respondent authorities, which is evident from the impugned letter dated 19 February 2019, whereby the direction have been passed as not to renew the service of only those individuals who had approached the honorable court, excluding the individuals who did not approach the honorable. It's very clear, man. And that apart, my lord, 2 of the writ appellants herein, they were given temporary appointments under compassionate appointment, my lord. And compassionate appointment, my lord, as per my understanding, my lord, can never be temporary, my lord.
How much you were getting per month?
My lord, my skill pay, my lord, it comes to 12,700
Per month.
per month, my lord.
May I make my submission also? Your Lordship, I am also submitting, Your Lordship, that the length of service as temporary employees does not entitle them for being
That is
regularized.
all right. The only prima facie wrong you have done, you have renewed everybody except those 9 who filed writ petition.
No, Your Lordship, that is not correct, Your Lordship. We have renewed. It is not a question
How
of
have you dealt with that paragraph in the writ?
affidavit in opposition. Where's the affidavit?
Otherwise, there is no issue at all. It is
Yes,
temporary
Your Lordship.
appointment for 3
No,
months.
all of them have been filled up by a regular candidate, Your
We
Lordship.
are not throwing anybody out.
By a regular candidate, they have been.
How have you dealt with paragraph 9 of the writ petition?
Where is that here? Affidavit is here. I think affidavit is not a part of this appeal. Yes. Your Lordship, affidavit is not a part of this appeal, Your Lordship, so I do not have it with me. Is
You
it
have
here? Oh, yes, Your Lordship, it is here. I have stated, Your Lordship, at page 69.
Affidavit is, my lord, is annexed there, my lord.
Yes, it is all right. I have found it, Your Lordship. At page 69, Your Lordship, it says that in reply to the averments made in para 9 of the writ petition, the answering respondent humbly submits that same are false, not sustainable, and hence denied. In fact, the Director of Health Services Shillong had issued the letter dated 19/2/2019, whereby requesting the District Medical and Health Officer West Khasi's Longstoin to immediately release the pay and other allowances to the petitioner in compliance with the order of this Honourable Court dated 15/11/18, passed in WPC number 412 of 2018, and accordingly the concerned Treasury Officer West Khasi has duly released the salaries of the petitioner for the period of her service as per the appointment order. Therefore, the impugned order dated 19 passed to the respondent is fair, reasonable, and legally sound, Your Lordship.
They have not
Now, Your
repeated
Lordship, my friend has tried to show that the order or the letter dated 19/2/2019, whereby the Director of Health Services had
What he says is when he filed the writ, he was in service. He only wanted.
He said that do not renew any, not only these 9. A general statement was given,
the salary and allowances which had fallen due.
due, and
That time,
that
the cause of action of non-renewal, etc., did not arise.
did not arise because this was a general statement, Your Lordship.
But there is no denial of this assertion that 9 individuals who filed writ petitions were excluded, others were renewed.
No, Your Lordship. Because in my additional affidavit, we have stated, Your Lordship, in the additional affidavit before this court, that it was out of the 31 officiating employees at para 3 of the additional affidavit, it is respectfully stated that the courts are bound by the issues raised, but anyway. However, in this instance, the appellant has raised issues. 31 officiating employees who, along with the appellant, were temporarily appointed in the office of the District Medical and Health Officer. It is stated that appellant alleged to have been singled out 8 for non-renewal of service under orders 2, whereas the remaining 12 were retained by virtue. The list we have shown, Your Lordship, that
Kindly see the list.
they were not the only ones that were not renewed, Your Lordship. All of these other 31 employees, most of them, Your Lordship, were replaced by regular candidates.
That is regular. But till the regular appointment was made, 2017, everybody's ad hoc thing expired.
Yes, Your Lordship.
Regularization was in 2019. So till regularization was made, the ad hoc arrangement was renewed. They were only left out.
No, it is not.
There is nobody can say that they should be regularized or that they had a very permanent right for renewal after renewal of temporary appointments.
So, Your Lordship, then let me seek instructions, Your Lordship, whether these people who out of the 8 others,
You were getting how much? 12,500.
That is my scale, man.
No, how much you were getting after deduction and all that?
we'll just find out whether they were being renewed after 2017, Your Lordship.
And out of these 9, how many who are the appellants before us?
Well, three more, my lord, they opted out not to, my lord, file the appeal.
Not to appeal. So who are the appellants?
6 number, my lord, Human Lang,
All attorneys, epithelial,
yes,
who are out?
out are, my lord. Rockcliffe is out, my lord, and
Rockcliffe
yes,
is out.
out,
Yes,
and
I think Bunsity Linkoy is out.
Bunsity
Your
is
Lordship.
out, my lord. No, Rockcliffe is not out, my lord. Paul Lindo is out, my lord. Paul Lindo is out. Bunsity is out, my lord.
and
One more. Sure, sir. One.
Yes.
Saradin. My lord, the third one is Saradin K. Buki. Saradi Dihun K. Buki. These 3 are out. And my salary comes to 41,000 per month,
41,000.
my lord.
How?
My scale is, my lord, kindly come to, my lord, page 58. This is the salary of ward attendant, my lord. As per revised structure, it is 41,000 per month.
What page should it be, madam?
I have not found that.
Page 58, my lord.
I think this is
28.
at page
58,
50, Your Lordship. At page 50.
This is the office letter dated 15/7/2019.
So how are you getting 41,000?
My lord, that is the,
Your Lordship, at page
because
50,
ward attendant is also 4th grade, my lord.
the
So the-
appointment order dated 1/4/2013 shows that the basics was 6,500 and the total emoluments was 12,700. That is Rockcliffe.
They are not entitled to regularization. And have also the punishment. Because they filed this petition. They were thrown out. Let them be paid 2 months salary each and this and no other obligation. 2 months because maximum government could have renewed for 3 months, then again renewal. But they did not have to work. They
All
had to be
great.
paid 2 months. And only these 6. Any other submission you would like to make?
Yes, Your Lordship. First and foremost, Your Lordship, it is that the length of service as temporary employees does not entitle them to to be regularized, Your Lordship, and this is
That is
settled.
3 months at a time.
Yes, 3 months at a time, and this is settled law as per Uma Devi, Your Lordship, 2006. Then, Your Lordship, these people, these employees had just been appointed without going through the regular process of selection, Your Lordship. So, Your Lordship, they have come through the back door and therefore they have no legal right, Your Lordship.
All right.
And their appointment was also not by the competent authority. Even as a temporary employee, they were not appointed by the competent authority, but at the district level by the district medical health officer. And which temporary appointments were never approved by the competent authority at any point of time, Your Lordship. Then, Your Lordship, as far as these 31 employees are concerned, Your Lordship, out of which my learned friend has repeatedly said that they have been singled out because they approached the Honourable Court for release of their salary, Your Lordship. The rest of all of them, Your Lordship, have been replaced by regular employees, either by the relatives of the landowners, or as per the government instructions, or by the candidates selected by the district selection committee, Your Lordship.
What is SB? Appointed as SB?
Stretcher bearer, my lord.
Oh, stretcher bearer. That is
The person who is responsible for carrying the stretcher, patient on the stretcher, my lord. My lord, here the state has given a complete go-by to Uma Devi's case, my lord. Now, having, my lord, taken my service for such a long time, my lord, the poor person should not suffer because of the go-by.
And, Your Lordship, another submission is that when they entered into service through the back door, Your Lordship, they were very much aware that they were being appointed on a temporary basis, and that any time they would be asked to leave, Your Lordship. So, having entered into that with their eyes open, Your Lordship, now they cannot turn back and say that they have been given a stepmotherly treatment, Your Lordship.
Yes.
And in this regard, Your Lordship, I would like to give some citations, Your Lordship. I'll just give copies of the...
Yes.
Perhaps I should give 2 copies, Your Lordship. I'll just arrange it and give 2 copies, Your Lordship. I've just got 1 copy each, Your Lordship. I've got copies here. This is my copy. Where is this? Can you give me one? How do you put it? 2 sets.
What is the proposition?
The proposition is that, Your Lordship, that
My lord.
as I made my oh, yours.
My lord, it's paragraph, my lord, 6 of, my lord, 1991-3 SSC 291, my lord. Is relevant paragraph
1
is
minute. (1991-3).
my lord, yes. Possible come to page 296, para 6, my lord. If I may read, my lord. In this context, the learned counsel also questioned the termination order from the another angle. In that order, it is mentioned that the service of the petitioner are no longer required, therefore they are terminated. But from the record, it is clear that junior to the petitioners are retained as they are continuing in service. In the affidavit, it is clearly mentioned the juniors whose names are not given there are retained in service in violation of Article 14 and 16 of the Constitution. In the counter affidavit, only a vague reply is given, simply stating that the averments made by the petitioners are not correct. In cases Joshi versus
Why are
Union
you
of
citing this case? This is, please read paragraph 1.
my lord,
Was directly appointed as an accountant.
my lord,
He was on probation. So this is a case of regular appointment.
regular appointment. Here I'm not before your lordship for regularization, my lord.
Then why
It's
is
on the
citing
point
this
of discrimination, my lord.
case? Discrimination everybody knows. Then next. Which is your next case? Yes. 2019, 13 SCC.
Your Lordship,
2009, 13 SCC.
2009, 13 SCC, yes, Your Lordship, Harminder Kaur and others versus the Union of India and others. The relevant paragraphs are paragraph 14, Your Lordship. A judgment of a constitution bench of this court laying down the law within the meaning of Article 141 of the Constitution of India must be read in its entirety for the purpose of finding out the ratio laid down therein. The Constitution bench in Uma Devi, in no uncertain terms, based its decision on the touchstone of the equality clause contained in Articles 14 and 16 of the Constitution. Emphasis has been laid at more than one place for making appointments only upon giving an opportunity to all concerned. Appointment through side door has been held to be constitutionally impermissible. We are not obvious of the fact that in some decisions rendered by the different benches of this court, taking a sympathetic view in favor of the employees who had been serving the state for a long time, the rigors of test laid down therein was sought to be dilated. However, some other benches of this court has interpreted para 53 in the light of the decisions mentioned therein. Then in para 17, the contention of the learned counsel appearing on behalf of the respondents that the appointments were irregular and not illegal cannot be, because, Your Lordship, since they have not gone through the process of selection and they have deprived other similarly situated people of being appointed in that post, Your Lordship, and who were more qualified, this was an illegal appointment. And so in illegal appointments, Your Lordship, even the para 53 of Uma Devi will not come to their rescue, Your Lordship. It is true that the respondents have been working for a long time. It may also be true that they had not been paid wages on a regular scale of pay, but they did not hold any post. They were therefore not entitled to be paid salary on a regular scale of pay. Furthermore, only because the respondents had worked for some time, the same by itself would not be a ground for directing regularization. Then, Your Lordship, the statement of law Then, Your Lordship, at para 23 of the same citation, Your Lordship, the bench noticed several judgments, orders of the different benches taking a view contrary to Uma Devi to opine that those cases were illustrative of non-adherence to the rule of judicial discipline, which is sine qua non for sustaining the system. It was opined in the Anand case, we are distressed to note that despite several pronouncements on the subject, there is substantial increase in the number of cases involving violations of the basics of judicial discipline. The learned single judges and benches of the High Court refuse to follow and accept the verdict and law laid down by coordinate and even larger benches by citing minor differences in the facts as the ground for doing so. Therefore, it has become necessary to reiterate that disrespect to the constitutional ethos and breach of discipline have grave impact on the credibility of judicial institution and encourages chance litigation. It must be remembered that predictability and certainty is an important hallmark of judicial jurisprudence developed in this country in the last 6 decades. An increase in the frequency of conflicting judgments of the superior judiciary will do incalculable harm to the system, inasmuch as the courts at the grassroots will not be able to decide as to which of the judgments lay down the correct law and which one should be followed. We may add that in a constitutional setup, every citizen is under a duty to abide by the Constitution and respect its ideals and institutions. Those who have been entrusted with the task of administering the system and operating various constituents of the state, and who take oath to act in accordance with the Constitution and uphold the same, have to set an example by exhibiting total commitment to the constitutional ideals. This principle is required to be observed with greater rigor by the members of the judicial fraternity who have been bestowed with the power to adjudicate upon important constitutional and legal issues and protect and preserve rights of the individuals and society as a whole. Discipline is sine qua non for effective and efficient functioning of the judicial system. If the courts command others to act in accordance with the provisions of the Constitution and rule of law, it is not possible to countenance violation of the constitutional principles by those who are required to lay down the law. So little differences also, Your Lordship, does not allow the courts to give a go-by to the settled principle of law, Your Lordship.
Are they asking for regularization?
No, my lord. My lord, if I may submit, on 5th
No,
March,
not. You have
They
finished.
are asking for reinstatement, Your Lordship.
my lord, on 5th March 2024, I had submitted my written argument and citations relied on my
Where?
on 5th March 2024. It's on the record, my lord.
No, that is all gone. It is a de novo hearing before this. You can't.
Because I haven't got a copy of that also.
You are also citing 2020-15 SEC 466.
Yes, Your Lordship. This is State of Bihar and others versus Devendra Sharma, Your Lordship. Here also, it's the same principle, Your Lordship. They are saying that once they come through the back door and the appointment itself is illegal, and despite the long service, no right is conferred upon them to be regularized or to be reinstated, whatever. And here, Your Lordship, the relevant paragraphs are 20, 21, 22, 20, 21, 22, 29, 35, and 44, Your Lordship. I will not read all those, Your
We will
Lordship.
read it.
And then, Your Lordship, I have also relied on 2023 Supreme Court,
Live law.
live law, Your Lordship.
Paragraph?
This is a short citation. The whole thing is service law. Working for a long period on a contractual basis does not create a vested right to regularization. The courts are no doubt sympathetic because they have worked for a long time, Your Lordship, but nonetheless, Your Lordship, the courts have said that we are also apprised that some of the petitioners have applied for appointment. But so far, we appreciate the last paragraph, Your Lordship, of the citation. We appreciate the argument of the petitioners that they have given their best part of their lives for the said college. But so far as law is concerned, we do not find the continuous working has created any legal right in their favor to be absorbed. In the event there was any scheme for such regularization, they could have availed of such scheme. But in this case, there seems to be none. We are also apprised that some of the petitioners have applied for appointment through current recruitment process. The High Court has rejected their claim mainly on the ground that they have no right to seek regularization of the service. We do not think any different view can be taken, Your Lordship. Then Uma Devi's case is there, Your Lordship. I am not taking it.
Yes, please take them.
Regarding the 31, I'm sorry, Your Lordship, for interrupting, but regarding the 31, which Your Lordship has said that they were continued to be renewed, whereas the 9 others were not, we are not sure about that, Your Lordship. Only that they have been replaced by regular appointed candidates. Because there's nothing to show that they were renewed.
Is there, my lord. It's clearly mentioned in the additional affidavit, my lord.
There are 6 appellants before us. Full stop. All of them were appointed on a purely temporary and contractual basis for a period of 3 months as stretcher bearers by the District Medical and Health Officer, West Khasi Hills, Nongstoin. The affidavit filed by the state shows that all these appointments were made between 2013 and 2014. It appears that from time to time, this 3-month period of appointment was renewed in case of each of the appellants. But not later than October 2018. Most of them were renewed only up to 2017. Paragraph. The cause of action on which this writ was founded was this. Full stop. The writ petitioners were entitled to immediate reinstatement and further renewal of their service from time to time. Paragraph. if one considers this ground of the appellants standalone, comma, they have no case whatsoever. Full stop. MST Yangi B, Learned Additional Advocate General, appearing for the state, has made the following submissions. On which basis we have made our above observation. Full stop. These temporary appointments were maintained for a certain period of time, but please stop. In 2018 and 2019, between 2018 and 2019, a regular recruitment process was carried out by the government, and all these posts have been filled up by regular permanent appointments. Full stop. There is no scope of any temporary appointment to continue. She has begun with the celebrated case of blank versus blank Uma Devi, reported in 2006 for SCC 1, where a 5-judge bench of the Supreme Court deprecated regularization of temporary or ad hoc employees, except under very extraordinary specified circumstances, and ruled that any public post is to be filled up fairly and transparently by a recruitment or selection process. In blank versus blank, reported in 2009, 13 SCC 90, the same court regretted that the dicta of Uma Devi was not being followed in some courts, which was continuing to direct the regularization of ad hoc or temporary or contractual appointments on some pretext or the other. it quoted official liquidator versus Dayanand, reported in 2008 10 SCC. Ten SCC page 1 to emphasize its view. First up, the following passage was quoted. Page 100. Of 2019-13 SCC, page 90. Marked portion up to page 101. This dicta was again reaffirmed in blank versus blank 2020 15 SCC 466. Bracket paragraphs 20, 21, 22, 29, 35, and 44. And in blank versus blank reported in 2023 live law bracket SC, 801. Paragraph. We do not at all dispute or differ from the proposition that these posts were purely contractual and temporary. For 3 months, full stop, the appointees had no right of renewal of this service, far less any right to regularization. Paragraph. However, there is one distinctive feature in this case. Paragraph. It was The petitioner has averred in paragraph 9 of the writ petition that subsequent to expiry of the contractual term, the service of all contractual employees except 9 were renewed. Bracket, till the regular appointment was made. Full stop. After, during continuance of their contractual term, these 9 appointees had filed writ applications in this court to claim their salaries and other dues full stop. The service of only these 9 individuals were not renewed.
Your Lordship, before me kindly interrupt,
No more submissions, please.
I just want to make a clarification on that.
No. You have made a lot of clarifications, no more. Unfortunately, this averment has not been answered in the yes. In the in dealing with this paragraph at page 9, at paragraph 9 of the affidavit in opposition to the writ petition filed by the state. Paragraph 9 of the writ petition and paragraph 9 of the affidavit in opposition paragraph C, pages 47 and 69 of the writ petition are quoted below. Paragraph. Therefore, this case narrows down to not any claim for regularization. Full stop. It centers around the remedy which the appellants are entitled to for being clearly discriminated against at the time of renewal of their temporary service, when the recruitment or selection process had not even been started. Full stop. In our view, the state has acted unfairly against the writ petitioners. Unfairly and a little maliciously against the writ petitioners, against the appellants, by not renewing their temporary service. Full stop. To this extent, they are entitled to some remedy from this court. Paragraph. At best, each of them was entitled to a 3 months renewal. Further renewal was at the discretion of the respondent. Full stop. They did not have to work. Full stop. In those circumstances, we dispose of this appeal by directing the state to pay 2 months salary or emolument to each of the appellants. Now, 2 months salary or appellants, which was payable to them at the time of renewal, or the first renewal. In 2017 or 2018. Full stop. According to us, this would be a just and equitable relief to each of them. The impugned judgment and order is modified to the above effect. The payment directed to be made by us should be paid within 8 weeks of publication.
Item number 10.
Mr. Clerk.
We see.
Which item number?
This is the gold matter, my lordship, wherein the gold bangle worn by the passenger who was traveling domestically was seized
Yes.
by the department, and subsequently the show cause notice was issued with a delay of 3 days. And the Honorable High Court single judge passed an order in our favor in April 2024. The said order was challenged by the department in an appeal wherein we are standing today, my lordship, for the arguments. And my lordship, I have to submit that the department passed an adjudication order in December 2024. The adjudication order is passed on the merits of the case, whereas the learned single judge of the High Court did not go into the merits of the case because our writ petition was based only on the question whether the goods must be released to him under section 110(2) along with read with section 124. And subsequently the order was passed. Now they have passed an order which has been adjudicated on merits, and my lordship, in their appeal, the prayer is not requesting the honorable court, praying the honorable court to decide the matter on merits. It is only on the subject whether the order passed by the learned single judge is correct or not. So, my lordship, my submission is the High Court has the power to protect the rights of the party in litigation, and the matter must be considered subjectively. What is the intention of the statute? The statute is saying that the goods must be returned to the person from whom it is been seized. So otherwise, apart from our coming to the honorable court, they should have themselves returned the goods back to the party. But instead, when we are approaching the court, honorable court, getting a favorable order, they file an appeal, and then they smartly play.
What is the value of the goods?
It's barely roughly 17 lakhs, my lordship.
17?
Yes, my lordship. 14 lakhs, my lordship. 14 lakhs. On the date of seizure, the value of the goods was roughly 14 lakhs, my lordship.
But what is pending before the High Court?
My lordship, their appeal, for which we are standing today, their appeal against the order of the learned single judge of the Honorable High Court, who had directed them to release the gold bangle to the petitioner, to the respondent in the present case.
But subsequently a confiscation order has been passed.
Yes, my lordship, that is what I'm saying, my lordship.
You have challenged the confiscation order.
I will definitely file an appeal because there is a time frame of 60 days from the date we receive the order. We are definitely going to challenge that order in appeal.
You have
That
not
is the
filed the
merits
appeal
of
up
the
to
case,
now.
my lordship. Pardon, my lordship?
You have not filed the appeal up to now.
No, we haven't filed, but there is still statutory time period of 60 days. There is still time till 5th of February. We can
But then
file
the
it on or before.
confiscation order has superseded your right to release of the goods under
So
100.
in that respect, I have a submission that the High Court has more power. It's a judicial body, and the government who's passing an order is a quasi-judicial body. Their power is less than the Honorable High Court's power. So they cannot supersede.
No, we are not on the
Honorable
we are
High
on the
Court's
power, on the effect of the confiscation order. The
Yes,
statute
Your
has
Lordship.
given them the power. The confiscation order
Absolutely.
means the property is vested in the government.
I totally agree that they have the right to file to pass an order, and I have the right to file an appeal. But the question over here, my lordship, is only to the single subject. We are here only not on confiscation, not on the merits, only on the question whether the order passed by the learned single judge was correct or not.
Yes.
Because this is their
So, so in one hand they will comply with the order and release the goods to you. On the other hand, by virtue of the confiscation order, they will seize the goods.
Yes. My lordship, they will pass an order which they have passed. I will file an appeal against that. Till this matter attains finality, this litigation attains finality, the goods should be in the hands of in my hands, because I am the aggrieved party and I am approached the court, and the law is allowing me to have the possession of that gold.
My lord, in my humble submission, because of the subsequent
The
development,
learned single judge here has directed release.
directed release, my lord, and only on the ground, my lord, that so-called notice was not issued within a period of 6 months. As
And thereafter, there is a confiscation order.
there, my lord, here what happened, my lord, even on the question of whether notice was issued within 180 days or not, the notice was signed by the appropriate authority, my lord, within time. Only thing, because of law and order problem in Manipur at that point of time, my lord, it was widely reported in newspaper that because of serious communal
That
violence.
is not correct, my lordship. If
May I just complete? May I please?
Yes, I'm sorry.
Now, my lord, what learned single judge has held, my lord, because there was a factual error. Learned single judge held that the so-called notice was supposed to be posted from Shillong, and in Shillong there was no law and order problem at that point of time. But the fact is that only the signing authorities from Shillong, my lord, the notice was to be dispatched from Imphal, my lord. And
No,
it was-
that the appellate court will decide whether they were entitled to release or not. But as of now, according to the learned single judge's order, they are entitled to release of the goods. But then that has been followed by a confiscation order passed by you.
that has been followed by confiscation order, my lord. My lord, if I can draw an analogy, as I submitted on earlier occasion, if somebody gets a default bail for non-filing of charge sheet, my lord, and in the meantime he is convicted of the offence, my lord, so his right is obfuscated, my lord, the right that accrued to him at that point of time.
There is a difference, my lordship, in that. Suppose the conviction is done, but he still has a right to file an appeal. And in the higher court, if he gets relief, then what? I have a question, my lordship. If this case was not, their adjudication had not been done, and this honorable court would have decided the merits of the case, like whether the order passed by the learned single judge was correct.
All right,
And
but in
if
that case, what security you can furnish? Can you furnish a
there is
bank
no
guarantee for
provision.
14 lakhs?
My lordship, first of all, there is no provision in the law which
No,
is
no, no, no.
going to be binding on me.
No, no.
as
You
per
will take
Customs
you
Act.
will take the goods and then they will have no right of confiscation.
Then, my lordship, I kindly pass directions that the custody of the gold may be in my possession.
No, no,
I will retain it till this litigation attains finality.
no. Then what is the guarantee that you will retain the goods and not dispose them of?
My Lordship, the government has the power to liquidate my assets.
My lord, I do not understand what is the joy in holding
Not deplied with that.
that particular article, my lord, till the file an appeal or get an order from.
All right, we will continue hearing tomorrow.
My lord.
My Lordship, may kindly keep it for day after tomorrow. I have a difficulty tomorrow, My Lordship.
No, day after tomorrow, there is some difficulty.
Or, My
Then
Lordship,
in February,
3rd of February.
5th or 6th February.
All right, My Lordship, 5th February is fine.
All right. List this appeal for further hearing on 5th February.
I'm highly obliged.
Yes. Item 11.
Item number 11.
Please, Your Lordship.
We will hear this by tomorrow.
Lordship, I had a small submission, my Lord.
Yes.
I am the respondent in this appeal. Lordship, before the learned single judge, I was the writ petitioner. I had filed a fairly comprehensive index of judgments in support of my contentions, and learned single judge had taken cognizance of all those of that particular index. Index, my Lord, is not part of the memo of appeal filed. If Lordship allows, with Lordship's permission, I'll file that memo of index. I'll prepare that memo of index because that'll be important for this honorable bench to adjudicate.
So, otherwise, the appeal is ready for hearing.
Otherwise, it's ready, minus the index, my Lord.
The
Respondent.
memo of appeal, a paper book has been filed.
Appellant has not yet filed any paper book, but the memo of appeal itself is fairly substantial, minus the index which I'm speaking of.
Memo of appeal, we have enclosed everything, Lordship. All the annexures as writ petitions.
What do you want to include there?
A memo of an index of judgments which I had relied on before the learned single judge, which I had filed before the learned.
You will add to that.
I can hand it over, my lord. I can prepare.
No, that is all right. That is not part of the appeal records. The memo of appeal is.
Memo of appeal.
Yes. When do you want to argue this appeal?
Next week, my lord. Next week.
By consent of learned counsel for the parties, list this appeal for further hearing on February 5th.
Let it be 6th, Lordship. 5th, we have some other matters
Where?
in single judge
So
bench.
here also there are other matters. So
Lordship.
if you get engaged in some other court, let it be mentioned. We will not take it up.
Lordship.
But the convention is that you have to give priority to courtroom number 1,
Lordship.
and then to the next senior court thereafter.
Lordship.
That is what we are aware of.